Cathy Trust Digital Library. It has 8.7 million volumes, and it's all, they're not sharing it anymore because they're afraid to share it in case some of the works in there are orphan works. 85% of them are orphan works, and they're afraid to share this with all of us. So the question is, what good is copyright doing if it's controlling our access as the human population to works that are important for all of humanity?
May I comment on this? I'm always, as I said at the beginning, I'm always worried to be so sharp in any statement. I think that we have to debate in a fair way, which is the right balance. And it's true that, first of all, there is a misunderstanding that should be removed from this table, I guess. That is that the copyright protects the knowledge and forbid the access to the knowledge. This is completely false. From technical point of view, the copyright protects the form in which the knowledge is expressed. So the problem that has been raised by the Malaysian lady is a problem with the patents, not with copyright. It would be impossible with copyright. Copyright is a very well-designed structure precisely for this reason, because it is aware, the system is aware in some way that we are speaking about goods that have some elements of common goods and some elements of private goods. And the right balance is precisely in this idea of the copyright, to protect the form and not to protect the knowledge behind the form. So it is completely possible with the copyright legislation to share the knowledge. There is no impediment on that. And there is no impediment to live for free with the Creative Commons. There is no impediment in doing what you do, or what I did many times. I published some papers in open access. Even the publishing associations published some documentation in the Creative Commons licenses, non-commercial. Because it's completely within this framework. And this is the strength of this framework, in my view. And what happens when the framework is challenged in the wrong way? Again, an example from the Google settlement is nice, because since they invented this system that was based on opt-out for out-of-commerce works, in the definition of out-of-commerce works, if an author released a work in Creative Commons non-commercial, and is public available, this information, according to the settlement said that Google could use in a commercial way against the willing of the author. And it was in the settlement. So when someone challenged the copyright concepts, is precisely challenging the decision of the authors, whatever the decision is.
Bonjour, je suis...
Good morning, Najee from Morocco. I just wanted to take up on what the Malaysian lady was saying, talking about general common good. I also wanted to take up at a national level and at an international level, because we are here in an intergovernmental space. I am not an interventionist at all. However, there are some facts. If we consider the idea of concept and information sharing and sharing of creativity and knowledge, I think that we can devise some public policies that negotiate with authors a minimum level of protection of the rights to the advantage, to the benefit of a large access. And here I would join Mr. Adam, what he said in Geneva in 2003, and that could help us bridge the digital gap. At In Morocco, for instance, we are talking about access rules, but no one talks about an act on access to international information. I was wondering whether there is any information about this. If we take the same approach, we can conceive that it is possible in an intergovernmental space like this to find a way, to find a system, because, we are encouraging understanding between peoples, between cultures. The problem of so I wonder, is it possible to have an international policy to protect rights, but at the same time to encourage the sharing of works between cultures? Thank you. Is there any response, any reaction to this contribution? No, that is not the case. So,
Late agreement.
Thank you. Good morning. May I? Yes. Good morning. Maurizio Lunghi, Fondazione Rinascimento Digitale. Prima di tutto vorrei partire con una considerazione.
First of all, I would like to say something. The title of this forum is The Future Book. The book is a vehicle to transmit, to convey culture, and I'm sure that the future will be on the internet, so I think it will be about e-books. I'm somewhat puzzled because over this day and a half, I didn't hear very important topics mentioned. We are talking somewhat anachronistically about copyrights. Copyright looks like the solution, but we're not talking about many opportunities that exist, but we don't talk about them. Namely, we're not talking about how roles and scenarios are changing between players, publishers, forms of communication, and so on. This is changing radically on the internet. This is, I think, a topic that I would hope would be dealt with in more detail. Additionally, we just hinted at open access and movements similar to that. These movements claim the right to free access to some publications made by public institutions or research institutes that are funded by public institutions. So we do not understand why they should be paid for a second time. And then third subject that I didn't hear mentioned is the preservation of these digital objects. Much of the content is digitally native, and the conservation, the preservation of these objects in non-commercial circuits is at risk. This is a topic that I think needs to be studied further. There are some initiatives by libraries and authors in this sense. I think it is really an important topic. What is your thought on this?
Thank you for an important series of questions and everything associated with the nature of the digital document, preservation, open access, and being parts of these things. I'm being called by time now, and I'm being asked, in fact, to essentially close very, very soon. So I'm going to take one more question, and I think you had been asking for quite a while, and make it brief, please. Okay, thank you.
Bonjour. Est-ce que Christian Roblin, France.
Roblin, Francia, Christian Roblin. I wonder whether we don't risk being totally overcome by the young people. I see some very brilliant young people who have some excellent results at school, for example, who never ever read a book, who never read any protected work. They read only what is not protected by copyright. Therefore, there are educated sections of educated public who were not at all interested in books. What will the value of distinction be of the publishing event when someone will put texts on a blog? Texts whose quality or added value would not be perceived. Of course, there are the very big publishers who publish law, medicine, science, and so on, because they will have forms of revenue that don't come from this. And another big problem is, how can one become aware of copyright if they have never ever heard about them, if they have grown up in an environment where they have been allowed to totally ignore copyright? So I really wonder how we can change this state of affairs, and wonder what kind of answer we will be able to provide in the case of fiction books where there is some sort of protection, or some databases where there is protection. And I wonder what will happen to other publications which are not databases but which have no protection whatsoever. I think that we need to close this session. I would like to thank you for having borne with us to the bitter end, so to say. I would like to thank all the panel members, and now we shall take a short break for coffee, after which we shall break up into sections.